As mentioned before, the appeal is now presided by a hearings judge, not the mediation judge. The hearings judge will not discuss your case with the mediation judge nor review your file, so be prepared to introduce all your evidence. A BIIA hearing is like a trial in Superior Court, but in this legal process there isn't a jury. The hearing takes place in the county where the injury occurred or where the worker lives, unless the worker requests a different location. Unlike a trial in Superior Court, the hearing will be held in a public building, like a library, city hall, or board hearing room.
Dr. Smith, are the opinions of a physician such as Dr. Young the kind that are generally relied on in making an opinion in this kind of a case?
Yes.
Like in Superior Court, understanding the legal process and terminology is daunting for the average citizen.
Objection, Your Honor. His question calls for hearsay. It's still asking for the opinions of the doctor, not the underlying facts and data as the rule requires.
Counsel sustained.
This is why hiring an attorney to represent you is highly recommended. The appellant will present their evidence first. The burden of proof lies with whoever is making the appeal.
So I think you've already laid the record, counsel, that she has looked at Dr. Young's report. So you can move on and ask her more questions about the examination or proceed with some other reports that she might have looked at.
If the opposing party presents evidence, the appellants must be more convincing. Please remember this very important point for your appeal. Only the evidence presented at this hearing will be considered in any additional stages of your appeal. So if you decide to appeal the outcome of this hearing and move your appeal on to the next stage, no new evidence will be allowed. Here are some guidelines regarding medical evidence. Medical testimony is required to determine the following: allowance of the claim or acceptance of medical conditions, reopening of the claim for aggravation of an industrially related condition, further proper and necessary medical and surgical services, payment of unpaid medical bills, time loss compensation, permanent partial disability, permanent total disability. You or your attorney will make and respond to evidentiary objections based on the rules of evidence. The court record keeps track of everything that happens at the hearing and is very important for future appeal proceedings. Here are key points about the hearing. You are encouraged to hire an attorney. The judge can only give you limited help. If you are a claimant or employer appellant contesting the decision, you need a doctor to testify on your behalf. You need to make arrangements and pay fees to have some of your witnesses testify. Only the evidence you introduce at the hearing will be considered in subsequent appeal processes. You need to prove that L&I's decision was wrong. Even if you are a party who agreed with the initial decision, you need to be present and involved in the appeal process to protect that initial decision.